Hi everyone, today we are going to be talking about Chapter 4, which covers intellectual property. So we're going to cover a little bit about the legality of intellectual property, and your discussion questions from this chapter are really about whether or not our legal system is what is best for intellectual property rights and what makes sense for software in particular. So we're going to take a look a little bit about what intellectual property means first. So intellectual property is the unique product of human intellect. Okay? What this means is that our ideas, what we generate out of our thoughts, out of our intellectual work, is defined as intellectual property, right? This is usually things such as books, music, and in our case, is going to include software, right? So this is the intellectual work. This is not things like building a product. Building a product like a belt or a piece of clothing or a house, those are physical property, right? So physical property are things that we can pick up and we can take with us somewhere. So technically speaking, I'm going to pick up my book here. So this is a piece of physical property. The contents of this book, so this is the ethics textbook that I'm holding up here. The book itself, this particular copy of this book, is physical property. However, the contents of this book, right, if I were to open up and copy a page out of here, for example, that's intellectual property. Intellectual property is the ideas, and the physical property is the physical manifestation of those ideas. So for example, I might be able to patent or otherwise hold intellectual property over a blueprint for a particular physical object, but the physical object itself falls under physical property protections, which means that if I were to try to reproduce a physical object that was maybe patent protected, I could run into issues with the law. But if I just use, buy, or otherwise find a copy of that object, I can use it without consequence because the physical and the intellectual are two different aspects here. Now, there is something I want to talk about with regards to the second treatise of government by John Locke. All right, so John Locke basically defines what we have rights to as property. And there are three main things that we have property to under John Locke's definition. So the first of which is property to your own person. So property of your own person means that you have a right to your physical body, to yourself, right? So no one is going to own you. That's the idea. Now, what historically that's meant is a completely different conversation, but the second treatise of government says that you have a right to your own person. Now, the other thing that it says is that you have a right to your own labor. So this means that any labor you do, it's your right to, well, one, do it or not, but two, also get paid for what you do. And the third is the right to what is removed from nature. All right, so right to what is removed from nature by your labor. That one's a little bit longer. Right, so you have a right to your own person, a right to your own labor, and a right to what you produce or labor off of the land or out of nature with your own personal labor. All right, now there are some conditions on this. So the conditions here are that first, no one claims more than they can use. All right. So this means basically that you can't claim more land than you could feasibly work, right? You don't overstore on natural products such as wood or food or other things, but also the next condition here is that removal from commons. So if you remove food or land or trees or whatever from common ground, so from public land, there's plenty left. Right? So this is basically saying don't contribute to the tragedy of the commons. So those are the two conditions. Now, the idea behind this is that we can also apply this to intellectual property, or at least very similar concepts to intellectual property. So the idea that you have a right to the ideas that you produce, the labor of your intellect, and also the labor to that of which you, or to the products of which that you produce from nature, from your labor, as long as you don't claim more than you can use. In other words, that you're being rather responsible with your intellectual property rights, and that you don't take away from what others could use in the sense of Creative Commons. So we'll talk a little bit about Creative Commons and what exactly that means in a little bit of a later video. And the next videos that we're really going to talk about is the benefits and the cost of intellectual property and how that applies to particular types of intellectual property protections.